Hi, this is Chris German. Welcome back to the Apartment Dealer Show. With me today, I have Mr. Mike Brennan. Mike has been an eviction attorney specialist for over a decade now and specializes here locally in LA County, San Bernardino County, Orange County, Ventura County. You get the idea. So if you're an owner of multifamily, we should know the name Mike Brennan because unfortunately, at some point, most of us will need an eviction attorney. Now, Mike and I, and a handful of other professionals recently just conducted an educational webinar for landlords like you. And there was over 600 participants, and we gave those individuals an opportunity to submit questions for our review. Of course, we could not get through 10% of all the questions that were submitted. So today we're going to follow up on those questions. We found the common thread, the common questions that most landlords have on their mind, and Mike's going to address those for us here today. Be sure to subscribe to our page, give this page a like, share it with friends. On this page, you'll find the resources, the network of professionals, the strategy, the information it takes to be a multifamily owner, what it takes to move your financial legacy in multifamily real estate in a positive direction. That's what we do here. So now, help me welcome Mr. Mike Brennan. So Mike, thank you for being here today.
Good morning. Thank you for having me.
And in a savings of time, and just in fairness to those that have been following our video segments, I just want to mention at the outset here that as Mike and I dial down through your questions that have essentially carried over from our apartment owners educational webinar, please keep in mind, Mike has been gracious enough in the past to record a number of these interviews where we've gone through the weeds and the nuances of the various laws and the differences between different areas. We're not going to do that now. We're going to keep the answers, especially on the rent increase questions and the tenant eviction questions. We're going to keep them straight and to the point. We're going to put the links to those other interviews either on the landing page that you're looking at here or down below in the description on YouTube so that you can check out those other interviews where we definitely dive specifically into the issue of rent increases and tenant eviction. So I just wanted to mention that, Mike, to, again, save you time, save us time so we can, hopefully get through a good batch of questions here.
Sure.
Of course, as I mentioned here just a couple of weeks ago, we were together at our apartment owners educational webinar. We answered a good number of landlord questions there. But when you have over 600 people registering, obviously you're not going to get through all the questions. And so I try to find a common theme along the questions, and that's what we'll be going through here today. So let's talk rent increases because, for whatever reason, I know one reason, there were some eviction outfits that were giving the wrong information, but a lot of people were under the assumption that just as a blanket across the whole state, you could not give any rent increases during COVID. And I think that's where a lot of this stems from. They didn't realize that, true, in some areas you could not give rent increases, but there were plenty of cities, majority of cities, where you could give rent increases. So hence the question on rent increases. And so the first one here is, if a city does not have its own moratorium, a specific city doesn't have something unique they've created. So for all the other cities in LA County, currently we can raise rents, correct?
That's correct. Excuse me. If the city's incorporated, it's outside of the LA County jurisdiction, even though it falls under the county's moratorium, but outside of the county property, you can increase the rent.
But in the unincorporated areas, you cannot raise rents still as of yet.
So that's correct. If it's unincorporated, you're still limited until the county moratorium expires or the state of emergency expires. Or also, the other prohibition would be the inverse of what you said. If a city has its own moratorium preventing that increase, that like the city of LA, then you would be prevented from increasing the rent.
Yeah, this is the wildest thing to watch because, for example, for those of you that own in East Los Angeles, zip code 90022, the entire zip code is in the unincorporated area. So for over a year now, they've said no rent increases. And when you call, because I own in that location as well, when you call, they say, well, no, not as of yet. And we're going to have a vote next month. And we're going to have a vote the next month. And we just recently called here maybe 2 weeks ago. And they said, well, we're going to have another vote in January. So it's just wild that they continue. And all along, you have inflationary thing going on in the background, costs going up, can't raise rents. It's just very interesting. Now, when it comes
Can I add to that?
Sure.
I will point out to people that Los Angeles County plus several other cities have instructed their staff members to go back to the drawing board and start developing a way to rescind the state of emergency. So we are starting to see that they are at least thinking about how do we rescind the state of emergency now. But you are correct. Right now, it still exists.
So, Mike, then in Orange County, San Bernardino County, Riverside County, I know you serve all these counties as an eviction attorney. Again, unless a city within any of those three counties have something specific, aside of that, a landlord can raise rents right now.
Correct. One word of caution I would add about Orange County is, many of you and your members probably already know this, they just passed rent control in Santa Ana, and that goes into effect on November 19th. So before your members start launching increase notices, I would encourage them to go to Santa Ana's website and look up rent control and figure out if their property is covered by it, because they cannot raise rents.
Wow, just the cities just continue to drop like dominoes, and well, it is what it is. Okay, under AB 1482, unless a city has its own version of rent control, the allowable increase is 5% plus the local CPI, correct?
Correct. It's either, the way they word it is 10% or 5% plus the local CPI, whichever is lower. So right now, don't quote me on this, but I believe the CPI is 3.37. So if your property falls under 1482, your increase would be 8.37 approximately.
Sure. And one thing I'll say here is, as landlords, you shouldn't feel bad about raising your rents.
No.
And I was going to have you chime in, but because I just got that question twice yesterday from landlords is now the right time? It's probably always the right time, depending on your rental rates and what have you. Now, if you happen to be one of those landlords that you already know you're at market or above market, well, then, maybe not, depending on your take on the economy. But especially for those landlords where you're $100, $200, $300 behind, if you don't, just keep in mind, when it is time to sell or it is time to refinance the property is going to have a lower value, and that's going to hurt you at some point. And so I get the compassion maybe that one's trying to extend, but I heard you say, yes, you agree, Mike. Any instance aside of where I mentioned maybe because the rates are already high, from a legal's perspective, any other instance you might say, well, maybe don't raise rents in that scenario?
I don't think that there's another instance where I would say that particularly, but what I would say, and I think Stephen touched on this at our last seminar, is if for some unknown reason you're wondering as a landlord, is this the right time to do this? Then you don't have to go the full amount that you're permitted, but you should raise it something, even if it's $25 or $50, for two reasons. One, the point you just made, at least keep yourself within a striking distance of the market for value purposes. But more importantly, in my opinion, is you have to keep the tenants in that habit, in that mindset that I'm getting an increase every single year, because, and my own family went through this, when you don't do the increase, the tenants get in that habit. And then when you come back and try to do the increase, they complain anyway. They forget that you didn't increase their rent for the last couple of years. And so I think it's the wisest decision to raise it every year, at least some amount. And then the last thing I'll say is, we all know that vacancy rates are at roughly 2%. And so the rent increases are going through the roof. I just say, be conscientious about your increase. Definitely put an increase in place, but be conscientious about it, because as I've said before, if you're always going, for the maximum amount you can, there's two things that can backfire on. One, the tenants' rights groups use that all the time. They go to Sacramento and say, look what the landlords are doing. And that's why we see some of the legislation that we see. The second thing is, if you're going to increase your rents, I would highly encourage you to first go into the unit, do a 24-hour notice of entry, and inspect the unit to make sure that there's no habitability issues first. And if there are, get the habitability issues fixed and then increase your rents, because it's not unheard of when you increase rents for tenants to say, I'm not paying rent. And if they don't pay rent, your remedy is an eviction. And they're going to come back and say, well, look, it's uninhabitable because of X, Y, Z. So if you're going to launch the increases, go do an inspection, take care of any habitability issues, then increase the rents.
Now we're going to move on to tenant evictions. And again, I know this gets a little harder not to start, chasing every nuance of, every situation. But we'll try to be brief. So the first question that a viewer submitted was, if a tenant did not pay rent for some period of 2020, now what do they do?
2020 has two time periods, as you know. All they really need to do right now is the very first thing they should do is go to housingiskey.com and fill out their application and get the ball rolling with that. The second thing they should do is not try to do it themselves. Call a law firm like ours that does nothing but landlord tenant work, turn in all the paperwork, and have that firm, including the paperwork from the Housing is Key website, they're going to email them back. Have that firm draft the proper notices and protect your interests. Like I said, I'm not going to go into the nuances because we've done it so many times now, but it's that simple, whether it's 2020, 2021, moving forward. The first step is housingiskey.com, fill out your application. The next step is turn it over to a qualified law firm.
Yeah, and I want to echo, not just because Mike's here with us, but just because this is my firm belief. You let the professionals do what they specialize in. And okay, so you try to run your own eviction, you save a few bucks, and I hope I don't rub anybody the wrong way, but if your cash flow is dependent upon you doing your own evictions, your cash flow isn't high enough. We need to discuss other options here, because again, you should be able to afford a professional who's going to streamline it for you, make your life easy, take the stress out of it. And essentially now, with all the various changes in the rules, they're going to keep you out of hot water by you submitting the wrong form, not doing a timely form, or what have you. I never attempted to do my own evictions prior, and I for sure wouldn't do them now, given the climate of how things are. Now, here's a good question. So the landlord was proactive. They served 15-day notices for the protected period, the transition periods, and the tenants failed to return the tenant declarations. They failed to pay the minimum 25%. Now, what does that landlord do?
Well, I'm assuming that landlord's already filed for housingiskey.com, but you just move forward with the eviction. Just turn it over to a law firm. And I'll kind of give you some insight on what's realistically going to happen. There's only a couple outcomes that can happen once you file that eviction. One, the tenant's going to get approved, and they're going to go to court and say, hey, look, I've been approved. Great. The landlord's going to get their money at some point. We don't dismiss the eviction just because they show up with a letter that says, I've been approved. We wait until the landlord actually gets the money. Or they're going to, the eviction is going to work itself through the court system. The court's going to ask, the court's going to ask, has the tenant been approved yet? No, the tenant hasn't been approved. What's the status of the case? Well, either the tenant has or has not filled out their application, et cetera. It's going to move through just like a normal eviction. But if the tenant is not cooperating, that's a little bit different story, and I guess we'll touch on that in a bit. But if the tenant has literally refused to pay the 25% or return the declaration, your only option really, again, assuming you've completed your application on Housing is Key, your only option is move forward with an eviction. That's it.
Now, once a tenant has used up their 15 months of Housing is Key rent, can they be evicted? So that almost becomes a two-part question, because I wasn't aware there was a 15-month limit. Is that true? Is there a certain amount of months? Okay.
I thought it was 18 months, but let's just go with 15 right now. I thought it was an 18-month limit. But yes, there is a limit to how much they can receive. And once they move through, it will depend on when they come to the end. So if they came to the end, let's say this month, we're into this pandemic now, 18 months. And let's say Housing is Key said, yeah, we're going to pay everything, but you're tapped out now. Then next month, you would just move forward as normal. You've already tapped it out. I would still tell you, submit the application, because you're going to get the email back that says, hey, this tenant doesn't qualify anymore. And that's what will allow you to go through. But I would it's just like any other situation now. Move forward with the eviction.
And I remember the question a client asked me yesterday, and I didn't know the answer, and and I don't know how involved you are with helping landlords actually fill out the application for the rent relief, but there's a question apparently that says, do you plan to prosecute, or do you plan to evict, something like, and it's a yes or no question, and they weren't sure, is that a trick question, that if they said yes, then maybe they wouldn't get the relief. And if they said no, then they wouldn't get the relief. It's like, well,
it's the opposite. It's a good question. If they say yes, that's one of the criteria that the tenant has to meet, is they have to be facing an eviction. So, for example, if the landlord served a notice, like a pay or quit notice, then that tenant is facing eviction. But you can have a landlord filling out that application who has not yet served a notice. And that's why they're asking that, is do you plan to prosecute an eviction? They should be answering yes.
Great. And then our last question here with respect to this segment of tenant evictions. How do you properly evict a tenant that is not paying rent nor applying for rental assistance? So they're basically doing nothing.
Right. So it'll depend on where the property is located. So for example, I'm going to talk about the city of LA real quick, and then I'll talk about some other jurisdiction. The city of LA, and we face this all the time, you're not allowed to serve non-payment of rent notices. So the tenant really has no incentive right now to get on Housing is Key and fill out their portion of the application, because there's nothing that can be done to them. For those situations, and for your members there, I say call me, because as I've said before, I have a strategy, and we've been employing this quite a bit in the city of LA, that allows the landlord to serve those notices without running afoul of the moratorium. But I don't want to discuss this on where it's going to be put on YouTube, and the tenants' rights advocates are going to watch it and know exactly what I'm doing. And then they'll go to Sacramento and complain about that too. But for jurisdictions that don't have that prohibition, where the tenant says, I'm not going to fill out the application, that's I would say move forward with the eviction right there. And the way the law is written, it's pretty straightforward. You have to wait 20 days from the latter of one of two things to file the complaint. Either 20 days after you file the application, or 20 days after you serve the notice. That's why I keep saying, fill out the application first. The minute you fill out that application, it's going to go to the tenant. Now, the very same day, if you can, or the next day, you serve your non-payment of rent notice. Now the clock starts ticking. 20 days after, you can file that eviction. So if they're not cooperating, you really don't care. You just want to get that clock ticking, if that makes sense.
Sure. Okay. The next question that came in was, what type of evictions are judges approving right now? So I guess that would be hard, because you'd have to say for this. So maybe we could ask it the opposite way. Are there any issues where you see judges not evicting, where they're not really willing to hear the case?
Candidly, Chris, I don't think much has changed. Well, let me put it to you this way. I think it depends on the circumstances. I think judges are looking at the bigger picture. The laws do state that the legislative intent is not to evict people, to have all this debt taken care of through small claims. But what I'm seeing is the judges are really trying to be fair about it. So they have to follow the law. So for example, if a tenant comes to court and shows that paper that says, hey, I got approved for all the funds, the judge has to do what the law says, which is set a hearing and see if the landlord's been paid. And if they haven't paid, they'll set a hearing again. They'll keep continuing to see if the landlord's been paid. But there's no case out there that I would say the judges aren't evicting on, with the exception of if the case runs afoul of the moratorium. So for example, LA County, you can't evict tenants for unauthorized occupants, right? But I have a case right now we're working on where it's a little bit different. The tenant didn't just allow unauthorized occupants to live there. The tenant actually vacated the unit and is subletting the unit, is literally letting people live in there on a sublease. So that's a different story. So if and when we get to court on that, that'll be the distinction is, if it was just merely a case where they had allowed the unauthorized occupants, I think the judge would rightly look up and say, hey, this case is a non-starter. Your client, the landlord, is running afoul of the moratorium. But there's nothing that's going to court right now that I see that isn't being handled just like pre-COVID. If the case is a legitimate case and the evidence is there to support the landlord, and the tenant doesn't have good affirmative defenses, the judges are just, doing what they're supposed to do and pushing the stuff through. Now, I will say there's backlog. And so what judges do, even when there's no backlog, is many people don't know this. Judges get graded on how fast they can clear their docket, just get these cases off their docket. So judges love to act as a mediator and settle the cases. And some judges are great at it, some judges not so great. But there is a backlog, and what they're trying to do is push the parties to settle, that happened even pre-COVID. But if the parties don't settle and it moves forward, it's business as usual. You're going to have a trial, and somebody's going to win and somebody's going to lose, and the judges really don't have a dog in fights. They don't care.
Now, the next question here is along the lines of this case you're dealing with where the tenant is subletting the unit. In this scenario, the landlord's facing, the tenant actually is running an Airbnb out of the unit. So I can't imagine that this landlord wouldn't have had something on the rental agreement that said you cannot sublease. I don't know what the issue is, but they're asking the question, hey, the tenant's running an Airbnb. How do they get it to stop?
That's a great tie-in. So Airbnb, first of all, the lease is a very old lease. It's probably 20 years old. And so the language about subletting and assigning is not as good as the current leases, but it is in there. You're right. And so it is a violation of the lease just in and of itself. But again, there's a distinction between subletting and just allowing people to live there. Subletting or assigning is where you actually transfer some interest, like creating a sublease to somebody because you vacate. So Airbnbs are a unique situation. They actually run afoul of the contract, most contracts that say you can't sublease, and they actually run afoul of most zoning laws out there. And so there are strategies to deal with Airbnbs. Our firm typically starts off with a letter telling the individual, the named tenant, hey, you're running an Airbnb. And one thing I always encourage our clients to do, the minute they find out they're running an Airbnb, download all the pictures. Find out what all of the short-term rental platforms are. It's not just Airbnb. There's one called Fiverr, not Fiverr. I forget the names of them all. But there's several platforms that you can run that ad on. Go to all of them, find your property, download all of the ads so you have that as evidence. And then we start off with a letter, and our letter basically tells the tenant, hey, look, not only are you violating the lease, you're violating the zoning laws because you're acting as a short-term rental. Your options are typically, I don't want to get into too many details again, tenants' rights firms, no, I don't want them to know what we do. But the letter basically says, hey, knock it off or get out. And if you don't, we're going to file an eviction. And there's some other things we're going to do to you as well, on a civil level. But it's generally pretty effective. We have had people fight us, and we go to court, and they eat one of two things happen. If we have all those ads, and typically we do, they either lose the trial or, as they say on the steps of the courthouse, they agree to vacate and give the landlord back their property.
To your point about a letter, not just regarding this, but a letter can work in many situations where simply the fact that the tenant knows you're serious as the landlord, you have sought legal counsel, many times that is enough. And for those of you thinking, well, an attorney is not going to draft that letter for free. Well, right. And they shouldn't, because, it takes time and effort and so forth. But the point here is it's a lot cheaper in terms of money, and it's a lot less time if you can get the tenant to, if they're smoking and they're not supposed to be smoking, or pets, or any of these number of things. Sometimes, just starting with a letter written by a good attorney will help. Now, the next question that was submitted, go ahead.
I'm sorry, I want to add to that. In some jurisdictions, it's actually required. You have to give the tenant a warning. For like Santa Monica, you have to give them a warning first before, and even under statewide rent control. Just cause eviction, you have to give the tenant some form of a written warning first before you can terminate the tenancy. So yes, it oftentimes works to resolve the situation, and in some situations, it's actually legally required.
If this individual bought a building, the previous seller didn't have leases, so during their due diligence, they were just provided tenant estoppels signed by the tenants and the seller, and it reflected the tenants were on a month-to-month lease. Once you, as the purchaser, now become the owner at the close of escrow, can you force the tenants to sign a rental agreement given there is no rental agreement?
So that's a very interesting question because it'll depend on a lot of factors, but mostly where is the property located? And is there any sort of ordinance that prevents you from forcing a tenant to sign a lease, like a just cause eviction ordinance? If you're, let's take it from both perspectives. If you're in an ordinance or in a jurisdiction and your property does not fall under one of those just cause eviction ordinances, then the simple solution is, yeah, go to those tenants with a lease and a 60-day notice. And you give them both to the tenant. You serve them at the same time and you say, I'm terminating your tenancy, assuming it's month to month, give you 60. And here's a lease. And if you sign the lease, I'm going to rescind that notice in writing, and your tenancy will be reinstated based on the new lease. And in some circumstances, that's the best way to handle it, because now you've got them on a written lease. Let's say you're in a property that's in an incorporated city, and your property's only, let's say, 13 or 14 years old, so it doesn't fall under statewide rent control yet. You would want to do what I just said. You'd want to go there and terminate the tenancy and get them to sign a new lease. Because in a year or two, that property is going to fall under statewide rent control. And at that point, at least you've got some boundaries in place, what violations would allow you to terminate the tenancy. But on top of that, statewide rent control has a provision in there that says at the expiration of the fixed term of that lease, if the tenant refuses to sign a new lease with similar terms, that's grounds for terminating the tenancy. But if you only have an estoppel, then you can't make that argument. Or if you're in a jurisdiction like Los Angeles, where they're under rent control, the tenant just turns in an estoppel, and they have no written lease. No, you cannot force them to sign a lease. So again, it'll depend on where the property is located. Your strategy will depend on where the property is located. Estoppels carry the same weight in court as a lease does. So whatever they put on that estoppel is basically now your lease in the absence of a real lease. So if they put 2 people live here, and then you close escrow and find out 5 people live there, guess what? That's grounds for terminating the tenancy. Not right now in the moratorium, but when that moratorium goes away, you would have grounds to serve them a notice for unauthorized occupants, because the estoppel says 2, but they've got 5 there.
I guess the issue becomes all the other things. That's why a lease is multiple pages, right? The right. Issue of pets or no pets and all these other things, right? Like the estoppel is great. And I've even seen it in transactions I've been a part of where surprisingly an owner has no leases. And it's like, really, you've been running this on a handshake, and people do it. Yes. As strange as that may sound, people do that. Now, staying on the thread of tenancy, let's say based upon today's rules, you rent a vacant unit and you sign an 11-month lease with a tenant. Does it help to sign an 11-month lease? Because what you're going to do is essentially when the 11 months are up, tell them, hey, we're not going to renew your lease. And essentially you force them to move out. So you then can rent to a new tenant at the new prevailing rents. Is that a workaround in rent control if someone has an appetite for cleaning a unit every 11 months? Is that doable?
Currently, putting COVID aside, if you have a property, it would fall under what you're talking about is the statewide rent control, just cause eviction ordinance, which specifically says tenants aren't protected unless they've lived there a year or more. So yes, that's what the industry has moved to is roughly 9 months leases. I wouldn't go to the 11 because at the 11th you're playing with that 30-day window, and to me that's too narrow. But I think 9-month leases currently, the way the law is written, yeah, it's a legitimate legal workaround. And I wouldn't even call it a workaround. I would not even say that I would do it because I want to raise the rents. I would say I want to do a 9-month lease because 9 months is enough for me to know if that's a good tenant. During that 9 months, let's say they paid their rent religiously every single month on time in full. Great, you paid your rent. But every single month I've got the police coming to the building because you're throwing parties or something. So yeah, it's not just increasing rent. In fact, I would say increasing rent is probably on the lower end of the importance. What I want to know is, are you a good neighbor? Are you going to drive all my good tenants out during this 9-month period because you're just obnoxious? And if so, I'm going to give you that notice of non-renewal at that 8-month mark. So when 9 months hits, you've got plenty of time and plenty of notice. Right now, that's a legitimate workaround. What I anticipate happening is, because the industry moved in that direction, the tenants' rights advocates up in Sacramento, I already know they're working on tightening up 1482, and I suspect that's going to be one of the areas. So they'll take away that 1 year period and say any tenant that moves in, as soon as they move in, it's a controlled unit.
Now, jumping back to the rental agreements here for a moment, the next question is a landlord able to give a tenant an addendum to the lease, for example, asking them to pay their own water bill, requesting them to provide proof of renter's insurance? And if they are able to do so, are they legally, can the tenant dispute it, or can they, or the tenant is forced to sign an addendum?
Again, as always, it always falls to where the property is located, right?
Mm-hmm.
So in some black letter law in California, you wouldn't even need an addendum to do what you're talking about. You would do a 30-day change in terms of tenancy. Under many rent-controlled jurisdictions, though, it says that the landlord cannot just unilaterally change the terms of the tenancy. The tenant has to sign it. So that would be an addendum. But what you've got to be careful of is, for example, the city of LA. If you were to change the terms where now the tenant is responsible for their own water bill, whereas when they moved in, they weren't, the city could theoretically look up and say, well, that's an illegal increase in rent. You're diminishing their services because you used to pay for that. And that acts as an illegal increase in rent. So you have to know the jurisdiction where the property is located in and whether you can get away with it.
And I know that I called you almost on this same issue for myself for a building I had recently bought, because the seller had a 2-page lease, didn't address many of the common things that the newer leases address today. And so I asked you, hey, can I, essentially force them to sign the newer rental agreements that I use, that's bulletproof and essentially addresses everything? And you said, well, why even deal with the issue of force? Why not just ask them to sign? And if they sign, they sign. And then if they don't, then you deal with it from there. And they actually signed. We issued it with a cover letter saying, hey, as you know, we're the new owners. We're updating our records. Please review and please sign. And they signed. And so I didn't even have to end up dealing with, well, what are the legal aspects of it.
It's funny, if you start off the relationship on a really positive note, you'll get a lot of compliance. And you can take that in different levels. Let's say initially they say no. Then you say to them, hey, we're offering those tenants who sign by a certain date a $50 gift card to such and such, right? And if they still say no, then you say, hey, we're offering tenants who sign, we're going to agree not to increase their rent this year by some percentage, right? Whatever that amount is. So there's different levels you can escalate this to before you say, hey, guess what? We're going to terminate your tenancy, right?
Right.
So there's a lot of different ways to cut the deal, so to speak.
Sure. And I think, again, bottom line is you want to have good rental agreements in place. I know that at our live event, you mentioned one of the things investors can do to prepare themselves for the future is just have good documents.
That's key.
I know we've addressed this question specifically on a prior video. So for sure, again, I'm going to refer our viewers to the links, but I'll allow it to come through and ask it just in case anything's changed. New COVID rules for screening new applicants. What is public record and what is not? So is there any new nuances as we're renting our vacant units? Anything we should be careful to ask for and we should, stay away from asking for?
Well, I'm not aware of any specific rule off the top of my head. I've got so many ordinances floating around in there now. It's hard to remember every single one. But off the top of my head, I don't recall anything specifically prohibited from you asking other than the normal. Like you wouldn't ask them, are you married? Fair housing questions, for example. But what is not permitted to be used by you, the landlord in your screening, would be unpaid COVID debt. So any debt that popped up during COVID, if they were impacted. So one question you might be able to get away with, depending on your jurisdiction, and assuming it's not prohibited, would be, were you impacted during COVID? And if they said, yeah, that's fine. But what you cannot do is use that to deny them the housing. That's where you run afoul on the state laws. And so you need to be careful about that. There's nothing that says you can't ask, but there is stuff that says you can't use it against them. So another question might be, did you work something out? Again, I want to caution your members right now, because I'm not recalling anything specific that says you can't ask these questions, but I do know for a fact it says you can't use the answers if they were impacted against them. So before, if you have a member that's watching this video, and they should call my office and tell me what city the property is located in, and let me just do a quick search for them, make sure there's nothing prohibited. But asking, were you impacted by COVID? Has that been resolved? I think would be a couple of acceptable questions in many places. And if the answer to that is no, it hasn't been resolved, just don't use that in your screening criteria to deny them housing.
And some good common sense and a good read of character. I mean, these type of things go a long way as you're screening tenants. And that's one of the reasons why I rent my own units. I manage my own places just because, I mean, I have a client right now. She hired a leasing agent. It is a disaster what they've done in the marketing and in the tenant review. So not to say there isn't some good firms out there, but again, some common sense, good judgment, good forms will take you a long way in avoiding the headaches that many people come across.
Chris, I want to just add on to that real quick. Clients send me documents all the time to review to see if it's okay to move forward with an eviction. And like you said, there are some good management companies out there, but I will tell you that about 80% of notices I look at, whether it's served by the owner or served by a management company, about 80% of them are defective. So, management companies, they're doing their best out there. There are some good ones that are on top of it. But like you said, hire the professionals for their specific jobs. Don't hire a management company to do eviction notices. Don't hire an eviction company to manage your property.
Right, exactly. We've talked about the state of emergency, so this addresses that again. Gavin Newsom just here recently extended the state of emergency. Any piece of that affects landlords?
There's an anti-gouging provision in the law. It's actually a penal code that it will impact landlords. I would say it's not going to impact too many landlords, but it is out there and they should be aware of it. And essentially what it says is during a state of emergency, you cannot increase rents more than 10%. And if you did, you'd be in violation of the anti-price gouging laws, and you could be criminally prosecuted. And it has happened. I've talked about this on a prior seminar with you. Essentially, most properties are now going to fall under either a local jurisdiction's rent control or the statewide rent control, and they kind of cap it out at 10% anyway. So, or the lesser of 10% or whatever their metrics is. But if you're lucky enough to have that property, like let's say you're a single family home, you're not covered by rent control. Yeah, right now, because that state of emergency is in place, you want to be cautious about going above 10% because technically you're violating the price gouging laws.
Is there a way to deal with rogue, belligerent tenants without evicting them? So, we've all had tenants who they're in the gray area. They haven't exactly, they've paid on time but they don't keep the place exactly clean. They're not exactly the most friendly individual with the neighboring tenants, whatever the issue may be. How do you deal with these type of people that, they are creating an issue on the property, but maybe just not enough where you would suggest to, start an eviction?
The best thing you can do in those situations, well, there's a lot of things you can do. The first thing is keep it in your head. And I say that to my son all the time. What I mean is just because you have a thought doesn't mean you need to voice that thought. You don't necessarily want to go to that tenant and start expressing your concerns about their behavior. What you want to do is document their behavior. You want to document every aspect of it. And it'll depend on who they're harassing, right? If they're harassing the neighboring tenants and those are the good tenants, yes, of course you're going to be concerned about that. And you want to document that. And the way to document that is to get those tenants to notify you in writing every single time there's any sort of an incident. And I'm talking about dates, times, witnesses, specific facts. If they're using a bunch of profane language, use the exact language and give a narrative in your written complaint. And also at some point, let's face it, the good tenants get fed up with that and they notify landlords that it's their intent to leave. And so what you do in that situation, especially if the tenant does leave, is that's where you hire the law firm, you send a letter, and you notify the belligerent tenant, hey, look, you are creating a nuisance. And it's very well documented. You don't send them the letter until you've got your documentation. It is very well documented. And this is your warning notice. And the next time you behave in any similar manner, we're going to deem you to be a nuisance and we're going to terminate your tenancy. Now, if they're doing that to management, and again, it'll depend on the specific facts. If they're yelling and screaming at management every time management comes to collect the rents, again, management has to be professional, calm, cool, collected, and not necessarily voice every response that pops into their head. But the manager should document it as well. And a notice should go out to the tenant once we've got the documentation, just like a neighboring tenant. But you might actually work a little slower with the management because management's going to be held to a slightly higher standard, right? They're going to say, hey, the courts would say, this is your job. You deal with tenants all the time. So I would move faster if they're harassing neighboring tenants because you're going to lose your good tenants. And I would be more thorough, or I shouldn't say more thorough. I'd be very thorough for both neighboring tenants and management when they're being harassed. You just have to suck it up as the owner. You just let it roll off your back. Okay, whatever.
Right. Last question, but before we get to our last question here, Mike, if someone's looking to just have a consultation with you, get your thoughts on an issue they're having, what's the best way to contact you?
I'm really glad you brought that up. The best way to contact me is just first call the office. Call the office. First of all, 90% of people's questions, 80 to 90% can be answered by my staff. They're all highly trained and they're highly trained by me. So I walk through it just like I would give a seminar. I actually put all the staff through the seminars, teach them all this stuff. So call them first. And if they can't answer the question, or if it's really a legal question about an actual situation that exists, they're going to put you in touch with me. Now, a couple caveats about that. First, I'm incredibly busy. So your members have to be patient. I call everybody back who makes it into my voicemail, but it may not be as fast as they want. The second thing I want to add, and I want to apologize to whichever of your members went through this. At the last seminar, I gave an email address, and I'm going to give it again now. And they apparently sent an email, and then they got on Google and complained, what's the point of giving me an email if you're never going to call me back or answer the email? So to that person, I want to say a couple of things. First, I didn't get your email. I went through all of my emails, and based on what I can figure out, I don't see an email from you. Emails sometimes get lost. Second, if you did email me and you didn't get a response, call the office and tell them, hey, I shot an email, I haven't gotten a response. And then third, finally, remember, if you're calling and it's not about an active litigation case, it's just a question, you're seeking some guidance, just be patient. You don't have to, launch a negative review because I didn't call you back with your free legal advice. Try again. All of the firms right now are getting pounded with this stuff, and it's not the golden days that it used to be a few years ago where I would just pick up the phone and answer your question and move on to the next phone call. We're all kind of slammed. And by the way, the main number to call, it would be 626-294-0500.
And the email?
The email is info@mbrennanlaw.com. So it's M like Michael, BRENNANLAW.com. Or go to the website, plug in go to the contact us page, put your question in there. It's easier for me to respond to those sometimes than it is to pick up a call. But there's multiple ways to get in touch with us.
Well, and I think the fact that you are busy is a sign of your professionalism and your credibility, because if there's any eviction attorney right now that is able to sit around and just pick up the phone, that should tell you something about.
You probably don't want to go with that guy.
With their caseload, right? Okay. Last question here becomes more of a personal opinion question, but it definitely is on the hearts and minds of landlords, given all the unrest of today. What steps can landlords do to protect their real estate assets, given the changing economy and government regulations?
It's both easy and difficult to answer the question. The easy thing is to say, keep getting educated, keep staying on top of this stuff. I talk to so many landlords every day that really have no idea that a law changed or have no idea. I get people who email me, hey, my property's in rent control. I just served my tenant a 60-day notice of termination. You can't do that. You got to stay on top of this stuff. And in order to do that, what they should be doing is continuing to watch your podcast, continuing to get education from all the resources that they can. Go to seminars, go to webinars, learn how to screen your tenants, seek the professionals that, like we were talking about earlier, where, if you've got landlord tenant issues, you should be talking to a landlord tenant attorney, not a management company. If you've got management issues, talk to a management company. If you've got real estate issues, come talk to you. So stay on top of everything. And I know it's hard. Things are changing left and right, which is even more reason to stay on top of it. Make sure all your documents are up to speed. That's the key right now. Make sure your documents are accurate, they're up to speed, and attend a screening seminar somewhere. Learn how to screen, learn what due diligence you can and can't do to protect yourself. I've mentioned this many times. Sit down with your broker and make sure you're covered insurance-wise. We are seeing an increase in civil lawsuits against landlords. Figure out your game plans on, your exit strategy. Developing an exit strategy on your properties would be something on the top of my mind right now. Even if you don't have an exit strategy or you don't want one, that should be your exit strategy. So there's a lot of moving balls right now that they can do to protect themselves. And none of it's easy. It's all a little bit complex in this environment.
Yeah. And to that though, luckily we're in an environment where multifamily is very healthy. As of the recording of this, rental rates are headed up, values are holding, interest rates are still low. All the main metrics you would look for as a landlord are in the positive. And of course, there's other aspects like the local regulations that are in the negative, but people need a place to lay their head at night. Being a landlord definitely is a winner. Owning rentals is definitely a winner. But like you said, I think you mentioned earlier, some of this stuff, you just have to suck it up at the end of the day.
You need to be active in the industry too. I didn't say that and I should have. You've got to be active in the industry. You've got to know who your representatives are in both city and state and federal levels. You've got to send the letters, voice your concerns, your opinions. I'll tell you one thing that you should join a trade organization that'll draft those letters for you and give you all the phone numbers to your representatives. So it makes it easy for you to call them, make your concerns known. But right now you're going to have to be patient and try to navigate this stuff using the professionals, but you got to be active. Otherwise you're going to get steamrolled, or all of us are going to get steamrolled.
Mike, thank you again for being with us. Taking some time out of your busy schedule to inform and educate the landlords. I know I speak for all the landlords when I say that they're just grateful for all that you do for the industry, the services you provide, the insight that you give. So thank you again.
Oh, you're very welcome, Chris. I really appreciate it, and I appreciate your members that reach out to me as a result of these. Even if we don't end up doing some business, they have reached out to me. Obviously, your members find this very valuable. So thank you very much.
And we look forward to, of course, we have the holidays coming up and the start of the year, but come spring next year, we look forward to being with you, ideally in a live event where we can have several hundred landlords with us to, answer their questions and address their concerns. And so we look forward to you being a part of that come the new year.
Well, thanks. I'm looking forward to it too. Hope everybody's healthy through the holidays.
All right, Mike. Thank you.
All right, Chris.
Well, I hope you found today's show informative. We got through as many questions as we can. We can't make this a 5-hour session, but I hope we answered those questions that are most pressing for you as a landlord right now. Keep in mind, we're going to continue to share more educational content, whether I sit down with professionals from the real estate industry to address those themes, those pressing items when it comes to being a landlord, or as we dial down through the analytics in the market, or as I walk you through some of my own personal projects, multifamily properties that we're purchasing, selling, rehabbing. We're going to be sharing over the course of this coming year more information than we have previously. And we're going to keep you in tune to the direction of the market, the pulse of the market, and the strategies that it takes to win, especially amidst the climate that we find ourselves here today. So as we wrap up for today, Chris German, the apartment dealer, and as always, wishing you positive cash flow, tenants who behave, and much protection from Uncle Sam. Till next time.